Hi, I'm firearms attorney Gilbert Ambler, and today we are going to be talking about the rights of 18, 19, and 20-year-olds to possess and to carry firearms, to purchase firearms, to possess firearms, and to carry firearms, and where the different district courts seem to be going. We're going to be looking at districts, and we're going to be looking at decisions from the 4th Circuit, the 5th Circuit, the 7th Circuit, the 8th Circuit, the 10th Circuit, and even the 11th Circuit. And at the outset, I will tell you, to me, this is a ridiculous discussion to even be having, because if at 18 years old you can march off to war for this country, to me, it is very, very apparent that you should have the same rights as anybody else to purchase firearms and defend yourself in your own country. Nonetheless, we're going to talk about what the courts have been saying, and the good news is it's mostly good news. But before we dive into this, if you have not yet hit that subscribe button, go ahead, hit subscribe, like, comment, share, tell your friends about this channel. That way you and your friends can keep getting this important Second Amendment related content. First decision we have to talk about comes from Virginia, from the 4th Circuit. And this is a decision. There was a challenge to the prohibition on a federal firearms licensee, okay, a gun store, or manufacturer or importer for that matter, manufacturer, importer, or dealer in firearms, for selling handguns or handgun ammunition to somebody between the ages of 18, 19, or 20 years old. Okay? Currently, gun stores can sell long guns, rifles, and shotguns to an 18, 19, or 20-year-old under federal law, but cannot sell a handgun or handgun ammunition. That was challenged here in the 4th Circuit. The first thing the ATF tried to do was drag this case out and essentially tried to argue that, well, the plaintiffs in this case are reaching the age of 21, so they have no harm anymore. And because they've got no harm, since they can now go out and purchase a firearm, this case should be dismissed. Judge, don't even consider it. Thankfully, the judge did not buy that argument from the ATF. He allowed the plaintiffs to amend, to add additional plaintiffs, and in fact certified a class of 18, 19, and 20-year-olds. So, case went on. And the judge, although he has not yet entered the final order, it looks, as of the time of filming this video, appears poised to be about to enter a final order granting a nationwide injunction excluding a small portion of West Virginia and a small portion of Louisiana, which have their own challenges to this law going on, but a nationwide injunction across the rest of the country that would allow 18, 19, and 20-year-olds to buy handguns and handgun ammunition from federal firearms licensees, from gun stores. And before you get too excited, it's very, very likely the ATF has already signaled that they will likely appeal this law or appeal this decision, and when they appeal it, they will almost certainly ask for a stay and probably get that stay. So unlikely that this legal change will take effect just yet, but it's a good thing that we've got a federal judge applying the Bruin test and saying it's unconstitutional to restrict 18, 19, and 20-year-olds from purchasing firearms, from purchasing handguns more specifically, from a gun store. So that's 4th Circuit. Interestingly enough, the 10th Circuit, a Colorado judge, looked at this 4th Circuit decision, struck down or enjoined a very similar law that Colorado attempted to pass. Next, we need to talk about the right to carry a firearm. It's one thing to be able to purchase it. Can you carry it? Texas, of all places, when Texas passed constitutional carry, they passed constitutional carry for those over the age of 21. They got sued over it. The 5th Circuit, when they looked at it and applied the Bruin test, said it's unconstitutional to prohibit 18, 19, and 20-year-olds from exercising the same rights as everybody else. So that provision was struck down in Texas. Now anyone 18 or above can enjoy constitutional carry in Texas. So that's a 5th Circuit decision going the right way. The 7th Circuit, with Tennessee, considered a very similar issue to the Texas issue. And when Tennessee looked at it, they didn't even wait for the judge to decide. Instead, they entered what was called a consent decree, meaning they essentially said the writing's on the wall here, this is going to get struck down. So they agreed to remove the unconstitutional provision from their law and allow 18, 19, and 20-year-olds to carry in Tennessee. The 8th Circuit in Minnesota considered a very similar issue, arrived at the very same conclusion. The only outlier here, in fact, is the 11th Circuit, because a district judge in Florida decided that 18, 19, and 20-year-olds are not part of the people to whom the right was granted, the right to keep and bear arms, and therefore it would be constitutional to infringe on their rights. Thankfully, that decision has been vacated. It is going to be reheard en banc, meaning the entire 11th Circuit is going to hear it, and I am very hopeful that when the 11th Circuit rehears that case, that they will come to a very similar conclusion as that of the judges in the 4th Circuit, the 5th Circuit, the 7th Circuit, the 8th Circuit, and the 10th Circuit. So stay tuned. It looks like judges by and large agree that 18, 19, and 20-year-olds are part of the people, as they should be, and get the same Second Amendment rights as anybody else in this country. If you enjoyed this content, go ahead, hit subscribe for us. Like, tell your friends about it. Until next time.